All right, guys. So, the microphone seemed okay. I just wanted to check that again. We've had, of course, problems in the past where it gets to getting all through a full hour's worth of lecture, and all it is squeaky voice. So, thanks for bearing with me on that. So it's 11:33. It's the 18th of November for my Monday, Wednesday Political Science POSC 201 course. And we're going to continue today. They're not long lectures today. Today won't be a long lecture. We're going to continue today talking about the Bill of Rights, right? The first 10 amendments to the Constitution, ratified in 1791. As your essays in your text would have pointed to, originally there were 12 amendments that were pitched to the states, the first two really dealing with Congress and congressional pay, and those two actually did end up getting ratified, but interestingly enough, not till about 230 some years later, when a scholar, and then ultimately Michigan became that necessary state, the 38th state necessary for ratification. Other states had to as well, because you had to still get to that 3/4. But regardless, that then becomes the last of the amendments to the Constitution. The one again dealing with congressional pay. So the next. Uh, 10 of those first 12 becomes the Bill of Rights, and of course the first of those is the First Amendment dealing with religion. Congress make no law respecting establishment of religion or prohibiting the free exercise thereof. And of course the rights are written as a composite of different concerns that the states had and had as part of their ratifying agreements, if you will, as they went through and ultimately ratified the Constitution. They were conditions of ratification. And so you notice that in the First Amendment, the Second Amendment, the Fifth Amendment, certainly, you have kind of all of these different concepts that are related coming together as an amendment to the Constitution. There was some conversation as to whether the amendment should actually be put into the Constitution in the areas that they amended, that maybe the civil liberties should have been included in Article 1, Section 8 or Section 9, or the Ninth Amendment and 10th Amendment may have been put in, again, right around the necessary and proper clause. But out of style, it was decided that the amendments would just be added on at the end. Well, that creates a little bit of an issue because you're not taking parts out of the Constitution per se, unless they're specifically designated as being taken out. So the Constitution remains intact. The amendments then will list what portion of the Constitution is being taken out as it's amending that. And so you could see that for the necessary and proper clause, for example, and the 10th Amendment, it creates a bit of conflict. Necessary and proper clause, according to Marshall, ruling after the amendment, what becomes the 10th Amendment, is ratified by the states in 1791. The McCulloch versus Maryland case doesn't happen until 1819. And so it's obviously a number of years later where Marshall, the nationalist appointed by Adams, wanting a strong central authority, where he ultimately, through the Supreme Court, establishes the precedents that the necessary and proper clause allows for the Constitution to stretch itself, why they call it the elastic clause, stretch itself beyond the original words and maybe even the original intent of the Constitution, as long as it was needed to carry out some other power within the Constitution, and that courts, right, judicial review, the courts, the federal court, particularly the Supreme Court, will ultimately render decisions as to how far the Constitution can stretch. And again, this runs counter to the idea of the 10th Amendment, which was the concern the states had in their ratifying. If you go back and take a look at the ratification documents state by state, their concern was that those things not in the Constitution would be left for the states to decide, and that implied powers would be something negotiated. I mean, if we think about it as a contract, using that analogy of a contract becomes, it makes for some of these complex ideas to become a little less complex. If you think about yourself going in and buying a car, And in that process of buying a car, you can't buy it outright. So you're going to buy it out on time. And in return for the vehicle, right, you're agreeing to pay this amount of money. Well, if you go in and you say, okay, before I pay you this amount of money, I want to make sure that I have a year's worth of oil changes, and you negotiate that into the contract, right? Then there's an expectation that after you bought this car, you'll have a year's worth of oil changes. What happens if the other side doesn't honor its agreement, doesn't honor the year's worth of oil changes? Do you still have to pay for that vehicle? Right? This is kind of, again, putting these concepts, these kind of easy concepts, into this constitutional negotiation, which really is, for all intents and purposes, a written contract between the national government and the states, and between the states themselves, right, through the national government. But again, if one party is not carrying out its obligation, does the other party have to continue to do so as well? And the answer, clear answer to that, at least in terms of contract law, is no, right? Now, can you unilaterally make that decision yourself? No, this is where a third party would ultimately have to come in and to arbitrate, to decide between the two parties whether or not there's the contract is being breached or not. And again, that's a great role for the courts to ultimately play, and that's kind of the backbone of what is judicial review. But what happens when the arbiter has an interest in the outcome, right? So the car dealership, the arbiter, the judge, owns the car dealership, right? Or the arbiter is your dad and doesn't want you to have the car. If there's not an honest broker in this as an arbiter, then the process is tainted. And so as much as throughout history we've tried to keep the courts outside of this idea of Republican judges or Democrat judges, conservative judges, and liberal judges, from the get-go they have been. And particularly Marshall, putting his thumb on the scale on behalf of the national government when there's a true contest from the other party, being the states, on issues, well, in the case of McCulloch versus Maryland, on the issue of banking and whether or not the federal government had the authority to establish a federal banking system competing with the states and within the states, by the way, and or whether they could be taxed if they were going to be within the states. And Marshall, again, citing the necessary and proper clause, which for all intents and purposes was amended by the 10th Amendment, that it does allow the federal government to stretch. That stretching or potential of stretching, right? Can the government stretch? Not, gets us to the 14th Amendment to the Constitution, which comes after the Civil War. The Civil War itself was about how far does the Constitution go to stretch? Can it stretch to deny states slavery if that's what the state is choosing to do as a structure within its economy? And or does the Constitution have to sorry guys, I'm going to turn off my email here so it doesn't keep blinking. Or does do the states have to ultimately follow the constitutional process to try to weed out slavery, which of course takes the 2/3 of the House, 2/3 of the Senate going to the states, and then 3/4 of states to agree, which wasn't going to happen. Could the states unilaterally leave the system? That was a great question, and as we get to the 14th Amendment, because it becomes important leading up to the Civil War and then post-Civil War, for all intents and purposes, really the power grab that takes place after the Civil War towards nationalism, right? We talked last lecture about the dialectical method, right? The what is and the what could be, and that the two forces kind of fighting really that individual state sovereignty versus a national system. And now it might be individual countries like the United States as whole, and then this idea of a new world government, a one world government, and the Great Reset. Hopefully individuals had an opportunity to take a look at that as suggested over the last couple of days. And you may have read the policies of the Great Reset and looked at them and gone, yeah, that's a great idea. And yeah, I like this idea too. And yes, you know what, we should do this. And all of that's good and well. But there's a difference between doing something because you think it's a good idea and being forced to do something because you've given up your authority and power to say, you know what, maybe this isn't such a good idea, or maybe the citizens that we represent don't want to do something like this, and this heavy hand from on high, movement of power from the United States to this, the United Nations or some other world entity is going to have its downside. Well, those are the exact same arguments that were going on at the time during the states ratifying the Constitution. Do we want to give up our sovereignty as a separate sovereign country to this entity that will have taxing power, will have military power, and the power and economic power to decide and tell us what to do? Do we want to do that? Is that in our best interest as states? And that was the fight. And the concern of the states, of course, was, well, okay, if we're going to do this, then it has to be for the general welfare of each state. We have to believe that it's in our best interest. And only those things in this contract, only those things that we are giving up as powers to this national government are going to be there for this national government to actually do. And so when we think about this Great Reset, how are we going to participate? If we're going to participate, how would we participate in this process? What process do we have to ensure that as we've seen with the states, that the power that was held locally doesn't somehow spin out to this stronger authority that has a stronger military, that has the power to print money, and is really kind of with those two powers has held the states in check, even though the states at some points in time, including the Civil War, have pushed back. And so that's a really good question. Back to the Bill of Rights, though, if we keep with this idea of a contract, then the Bill of Rights really, again, is where the states themselves, the citizens of the states, were trying to mitigate or reduce the opportunities for what happened with the colonies and colonists with their sovereign, that being England, the king and crown and parliament. And that led ultimately to the American Revolution. And so to try to avoid that from happening, wanting to retain specific powers to ensure that we never got to that position. Didn't work. We got to the Civil War, which of course, for all intents and purposes, was Confederate states, the Confederacy, the separate sovereign states against the federal, right, government, the federal troops, the Union, right, which would be the national component of it. And that was the ultimate fight. Over slavery, without a doubt over slavery, but really over the contract and whether or not the states could continue with slavery or not, or whether or not that could be taken from them at any given time without a constitutional amendment. To Lincoln's point, as he was both elected as President of the United States, but also in his inauguration, but in that process of being elected, when questions about slavery arose, he said, look, when it comes to slavery, I'm either for it or against it, but I'm for holding this union together. And then when he wins the presidency, his inauguration, he says, look, we're not coming for your slaves, right? But it was too late. The South had already seceded from the Union. And to Lincoln's point, you as a party of this contract, nothing has taken place that has denied you any of your constitutional rights. So for you to secede, to claim this contract is null, is preemptive, and there's no, you don't have really a leg to stand on. In other words, you bought the car, we're giving you the oil changes, right? As part of the agreement, we're giving you those oil changes, but now you're saying you're not going to continue to pay for this vehicle you purchased. Where's the breach here? And in that regard, there was no breach as far as the argument from Lincoln and members of the North went. But from the South, they saw the writing on the wall. They could tell which direction this was going. I mean, the Republican Party was born specifically to do away with slavery, to stop its spread, certainly, but with the abolitionist component of it, to actually get rid of slavery. And kazan, and kudos, and good for that party to have that interest. But at the same time, the South could see that as the goal of the Republican Party. And so as more Republicans are elected for a Republican president, following the political party, the platform, then the writing was ultimately on the wall. So Zahaya is there. She's got a question. And Zahaya, it may just be actually you and I. So Could that happen now? The states separating from the nation, not slavery, of course. That's a great question, and the answer to that is yes, under the same argument that the South used for slavery. But there would have to, and that was, I think, even to Lincoln's point. Lincoln's point was, if there is something, that there is a constitutional breach between the central authority, the central government, and the states have the right to secede. Once this contract's been broken by the national government, then there's no legitimate there's no legitimate rationale as to why the other party has to stay a part of this contract. And so if you believe as a state that the federal government, the national government, is absolutely outside of the contract, the Constitution, and how it's treating you, then certainly I think that it would be within the right of the state to say, we're done. We're not going to play this any longer. Part of the argument from the North was that you don't have the ability or the power to unilaterally separate yourself. Well, I would, well, you can say all you want when it comes to this contract. If there's two parties in a contract, it's kind of like a marriage, right? If one party wants to get a divorce, how do you hold that other person into the marriage? I mean, you might be able to physically do that, right? Captively do that, but at the end of the day, a marriage takes both sides to be a part of it. And so if the states certainly thought that there was a true unconstitutional act going on by the national government, I think the states would be within their rights to separate themselves. Each state, as it comes into the Union, beyond the original 13, comes in via a process. Each individual who's elected to office takes an oath to support the Constitution. And our First Amendment does allow for the constitutional right for redress from the government. So I don't think the states would absolutely just work to, just say, like, tomorrow, we're done, we're walking away. I think would there be a full process in this, and the process would be to petition the legislature and to have our congressmen and our senators fight for whatever our interest is as a state. But if it seems like we're getting the short end of the stick, something outside the Constitution, I think we would be within our right as a party to separate ourselves from that contract. If, again, of course, you're making the argument, right, as the state, that you've done something unconstitutional. That's what the courts are there for, too, to kind of help us to navigate those things. Does this apply to the territories of the U.S. like Puerto Rico? Oh, that's a great question as well. I mean, the Philippines are a good example of a territory, a protectorate. The Panama Canal, another protectorate of ours that have been released for the sake of sovereignty, for those countries to establish themselves as their own sovereign. And I assume that if Puerto Rico chose to, since it's not a state of the Union, to sue, for lack of a better term, for its independence, that there's a process for that, and could indeed do that. And I think it would be wrong for the United States to hold Puerto Rico captive as neither a state nor its own sovereign, and just a quote unquote territory of the United States, if the citizens, the people of Puerto Rico, chose to separate themselves. The flip side of that is true as well. The United States may say, we no longer want you as a territory. We no longer want to be the protectorate, and so go on and do your thing. Again, I'm sure that there are processes written into this. I'm sure that the governments, particularly there's law and treaty that would be have to be taken a look at. But yeah, Guam, Western Samoa, the Virgin Islands, Puerto Rico are all non-states, but are part of the United States as territory. But again, at a point in time when we have connections to the Philippines, we had connections to the Panama Canal, and have since released those. Excellent question, really good question. So we left off. We were just kind of getting through the Fourth Amendment, and then into the Fifth Amendment. And as I said, each of these amendments to the Constitution, even though there was 12, and we boil them down to 10, they're multifaceted. Most of them have multiple concepts in them. The Fifth Amendment has a lot. And if we could take us through this kind of this, not the hierarchy, but the thinking going on, what was it that led to the American Revolution in the minds of the people of the states as they're ratifying and creating this new central authority and giving up, again, taxing authority and military authority to this national government, right? It was taxes that was part of our concern and argument, right? Taxation without representation leading to the American Revolution. And it was military, both occupation, intervention, kind of the military acting as a police force to impress upon the colonists the laws that came down from king and parliament without representation. And so if we think about it in that context, that's where you get the backstory of these amendments, right? The context of these amendments is in thinking what leads up to the American Revolution, and what do we as now separate sovereign states, no longer colonies, what do we want to guard against if we agree to this new contract with this new central authority, a different central authority, not a king now, but a president, not a parliament, but a legislature. What is it that we want to ensure that this government can't do, so we don't slip our back into the system where we don't have local control? And so that's the context of the Bill of Rights. Again, one in terms of compensation and structure of Congress, but then 2 through 12, right, becomes the 10 amendments to the Constitution. The first Congress, once Congress has taken seat, how they're compensated, what can Congress do? Well, Congress, it's not so much what Congress can do, what will Congress not do? These are limits that keep this national government from interfering with what the states and their citizens are already doing, right? The states precede the national government. And so the states already have laws, I assume, that they may choose to, I'd have to go back and take a look at those early constitutions. And they're there, by the way. The Avalon Project has those original state constitutions, but to see if they have any rights guaranteed within each state. I know they do, but I was thinking about the Second Amendment, if there's a Second Amendment right. In Michigan, in our state constitution, Article 1, which is our Declaration of Rights for our citizens, Article 1, Section 6, gives us, you and I, the power to protect ourselves via the right to keep and bear arms, right? So that is a power afforded us at the state level. So I don't know if other states, before the Constitution is ratified, had these gun rights protections, but I certainly know that was a concern of the states in ensuring that this new national government didn't leave them unarmed, right? Didn't leave them without the ability to defend themselves. And so as we think about the background behind the Bill of Rights, think of it in the context of what caused the American Revolution and how do we ensure that doesn't happen again? What were those grievances that really led to the fervor that led to us revolting from our sovereign? And those things would include, again, the quartering of soldiers, the clamping down of our religious rights. Remember, the Pilgrims, right? They left for religious freedom. Many individuals came here for religious freedom and established these different religious sects that became different colonies, Baptists and Catholics and Protestant and the Friends. The Quakers, all these different kind of religious groups and multiple religions as well. In New Jersey, very religiously diverse. There were Muslims and Jews in New Jersey as colonists when it was a colony. So again, religious freedom was something that was of concern, and creating a national government that would have this huge amount of authority and power to not allow it to come in and to actually establish a national religion, nor prohibit the free exercise, right, of religion within the states. over time, through what we call incorporation or selective incorporation, the ideas of that Bill of Rights have been pushed down to the states, to all governments everywhere. And so the concept of your right, your right for government to not interfere with religion, doesn't match up very well with the actual written language in the Constitution, the Establishment Clause, Necessary and Proper Clause, because they make sense that if we're creating this new government, that it doesn't involve itself either establishing religion or getting involved with how religion is to be carried out. You stay out of it. The states are already doing that. And so there's the concern is that this new national level of government is going to involve itself. It's not the concern that government is involving itself in religion. And so through that selective incorporation, I think it's a bit of a jump for judges to press down this concept of a separation of church and state as a constitutional right, where that constitutional right of separation of church and state really never existed. But as we continue through, so if we think about our individual rights, and then we think about our right to say something, speak out against the government, and then the protection against unreasonable searches and seizures, right? So the government has this power to lock you up. What's that process going to look like, right? Where's the onus going to be? Is it going to be on the state to prove its case or the individual to prove their innocence? And we wanted to ensure that the onus was on the state, that the idea that you could lock somebody up and then make them confess or prove their innocence, we weren't going to allow for that. That was going to be a protection. Again, the national government was not going to have the authority or the power to do that. To just simply lock individuals up and make them confess or let them rot until they confessed. And you can see that permeates the next of these amendments. So the Fourth Amendment is really about how the state gathers its evidence against an individual. So let's say that as a citizen, your government says, you may be doing something wrong. So the government then goes in and says, okay, how are we going to build this case against you? And it's got to go and gather evidence to build this case, because again, the onus is on the state now, not on you. I can't just simply say, you're guilty, lock them up, now prove that you didn't do anything wrong. The government has to prove its case against you. So that's where the Fourth Amendment comes in. It's not that the government can't spy on you or go through your stuff or seize your property. It's not that the government can't do that. It's that in order for the government to do that, there's a process that has to be followed. And so the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So there's a process there. So as an individual, if you're driving down the road, this is your property, you're driving down the road, and there are individuals say, well, as soon as you get your license or you're driving down the road, it's a privilege, it's not a right. And there's some truth to that, except for the fact that you're paying for the road. It's your road. This is your property as a member of society, as a citizen. So the right of the state to stop you in your travels or to search your vehicle gets closed in based upon this Fourth Amendment and your property. Now, how you drive, if it's erratic or dangerous, okay, the state has a role to play. But what's within your vehicle, it's questionable as to whether or not the state has a right to simply check into your vehicle. But for the suspicion, right, the probable cause that maybe there's something wrong, maybe you've got something in the car that is illegal. And so the question may be, hey, can I look into your vehicle? And the answer to that, particularly if you have something in your vehicle, should be no. You're not going to be able to look into my vehicle. All right, well, then that then forces the officer to then go through this process of getting a warrant that comes from a judge, right? The judge has to issue the warrant on probable cause. So what's the probable cause? Is it simply you were driving fast? That's not probable cause to check in your vehicle for drugs or for anything else for that matter. supported by oath of affirmation, so that the officer has to affirm that what they're looking for is true and honest, and then particularly describe the place to be searched, your vehicle, and the person or things to be seized. So what is it you're looking for? What is the particular thing that you're looking to? Is it something illegal? Well, that's a little overly broad. And all this does is it sets up the next step in the process, which is the trial piece, right? And that's where we get into the Fifth Amendment, right? The Fifth Amendment to the Constitution, the rights in the criminal cases. Zahaya says, if the police officer asks for a warrant to search the car, how long will it take to get the warrant, since he has to get the warrant through a judge? Great question, right? There is a long process, and they can detain you until they get the warrant, right? So this is one of those things where if you've got something in your vehicle that you do not want the police to find, which I'm not advocating for, but I'm just simply saying, do not allow the police officer to look in your vehicle. Make them go through this process, because this process then this sets up a number of steps that can then all be challenged in a court of law. Again, I'm not advocating on behalf of the criminal or criminal activity. What I'm saying, as a citizen, you have these rights, and you should know these rights. Part of the great thing about this class is the empowerment that comes with it. You are the citizen. The state has to prove its case, and whatever it is that you choose to do, something in your head says this is reasonable and okay to do this, right? Right. There are individuals out there who are not reasonable, who are not okay, but other individuals who are like, you know what? I don't really see the harm I don't really see the harm in inheriting my father's handgun, in transporting that handgun from his house back to my house. I don't really see a problem in that. But there are laws against that, right? It's not yours, not your possession. It's not registered to you. You're traveling with your transport. I mean, there can be laws against that. And so if you don't see that there's any problem with it, right? It's reasonable and rational to you. Why do you, as a separate citizen, as an individual citizen, have to defer to the state that this is the way it's going to be and you have to follow it? Again, these are the two entities here that are in the two entities that are in the argument, for lack of a better term, right? They're adversarial. And so what's good for the whole kind of represents the state's interest, and then what's good for the individual represents your interest. And what we said way back when is that the citizen has a place in this. We don't just defer to the state or to the leaders or to the elected official or to the despots that they get to tell us what to do. We get to make some decisions on our own, and then when there's a conflict, okay, then let's talk this conflict out, right? We don't just defer to the state and say, okay, the state always wins. And so again, you don't have a problem with it. The officer says, well, we're going to look for illegal contraband. The officer then gets a warrant, and they're searching your vehicle, because they can search anywhere in your vehicle, and then they find the gun that you've inherited from your grandfather that you are in possession of, that you're taking back. Maybe it's loaded, whatever the case may be, and now you're in trouble. So at least you've got this process in place. When the warrant was requested, did you tell the judge you were looking for handguns or a weapon? What was it within the warrant that you were ultimately looking for? Is it specific enough? Will a jury see it that way? So again, you're setting up the next step in the process. You've been pulled over, the police officers there, they're going to ask to search your vehicle. You've got something in your vehicle that shouldn't be there, whether it's, again, it's drugs, it's a unregistered firearm, you know, I don't know, you're transporting large sums of money. I don't know, whatever it ultimately is, they're going to find it. And so you're caught. The next step is, okay, what are the ramifications going to be? How am I as a citizen going to deal now with the state? And again, I'm not advocating for breaking the law. I'm simply saying, as a citizen, these are your rights. You should exercise these rights. The system is set up for this, right? There would not be the Bill of Rights protecting your right, forcing the state to get a warrant if you didn't if this wasn't supposed to be afforded to every individual, whether they're breaking the law or not breaking the law, right? So, so the Fourth Amendment, again, includes those things like unreasonable. What is reasonable? Probable cause. What is probable cause, right? So those are great questions for judges and juries. So now the state has gathered its evidence. What next, right? And this is where the Fifth Amendment comes in. So no person shall be held to answer for a capital or otherwise infamous crime unless on the presentment or indictment of a grand jury. So basically a felony crime, it must go first to a grand jury. Now, again, this was to the federal government, to the national government. So it was kind of a step in the process that said, look, before we even prosecute, you have to take it to a group of citizens, present your case, and ask those citizens, this grand jury, is there enough information here that would take us to court and give a likelihood that the state would win in court? Not even really 50-50, but actually a likelihood that the state would win in court. That's kind of the threshold. Because if it's 50-50, it's a crapshoot. Well, come on, that's not enough. That shouldn't be enough. If it's likely to be successful, okay, now you've got enough information, you should take this to court. Now, again, as we push the Fifth Amendment down to the states with a state law, a state felony, a felony within a state, they too have to convene a grand jury and run this prosecution, this information before them to have them come to a conclusion as to whether or not there's enough to go forward, right? It's pretty simple for prosecutors to get the grand jury to agree because it's pretty much a one-sided deal. It's pretty much the prosecution right before the grand jury giving their side to then move forward. There's an exclusion for the military. Military cases are handled differently regarding the military or the militia. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. So this is what we call double jeopardy. In other words, the prosecutor gets a bite, goes to the grand jury. The grand jury says, no, we're not going to have, we're not going to do that. The prosecutor goes forward. The jury themselves says, no, we don't find this individual guilty. Then the prosecution, the state doesn't continue to get to go after that individual, hoping for a different jury, hoping for a different, outcome by continuously, badgering the individual, the citizen, again and again for the quote unquote same crime. So you get a bite at the apple. The state gets a bite at the apple, and it better have all its ducks in a row. What else? The individual in the fifth, according to the Fifth Amendment, right, cannot be compelled. Right, cannot be compelled to bear witness against themselves. So no forced confess. We're going to keep dunking you in this water until you say you've done it. No. Again, we're not going to. These may have been the tactics under our last system of government. Hold you until you confess. Put you in an uncomfortable situation until you confess. Right, but that is not the way that the process is supposed to work today. This is a dumb question, Zahia says, but does the Supreme Court have a jury, or are they the jury? It's not a dumb question. It's a good question. So the first level, as we go back to and we think about that structure of the court. So as we get from the legislature, the bicameral legislature, to make the law, and then the top down of the executive. I told you guys I was going to get blinds. I haven't gotten blinds yet. But as the executive branch carries out the law, then you and I then in following the law versus the state enforcing the law, when there's that conflict, this is where the courts come in. And then from the courts, we talked about the courts as being from the bottom up, like a pyramid or a triangle. So the largest level is the trial court level, right? So everybody starts at the trial court, and that's where you have the jury, and that's where you have the prosecution and the defense, and you argue out the case. And then from that verdict, then you choose to appeal that or not. And then from the appellate court, you have the opportunity to appeal again, but juries have now gone away. Now you're asking the judges to consider the outcome of the case and why that outcome came as it did, and whether or not whether or not it should be reversed, or or somehow sent back down for a retrial, what we call remanding it. That's what you're asking of the appellate court if you've lost. And so the Supreme Court kind of acts as that entity that listens to the process and then considers the whole entirety of the law and then decides whether or not the process below is done correctly. So when they grant cert or certiorari, they're granting the process of making the decision more certain. All right. So that's not a bad question at all. So the Supreme Court doesn't have a jury. You're basically asking the Supreme Court a question about constitutional rights, constitutional protections, and whether or not they've been violated somewhere along the way in this process. And oftentimes the U.S. Supreme Court is the court of last resort. I mean, it is the court of last resort. Sometimes it's the court of original jurisdiction. So cases will actually start there without a jury. But more often than not, it's the cases that work themselves up through first the jury trial, then through the intermediate appellate court, then to the U.S. Supreme Court. Excellent question. So no double jeopardy, no being compelled to bear witness against yourself, nor be deprived of life, liberty, or property, right? Be deprived of life, liberty, or property without due process of law. So what does that mean? So we think of life, liberty, and the pursuit of happiness. Well, life, liberty, and property are, again, the rights of individuals, that you have this right to life, the right to be free. You have the right to your private property. And when those things are taken from you, your life, your freedom, or your property, then you must be afforded due process of the law. And due process of the law is just kind of a fancy way of saying the process due you, the process that's afforded to you and each and every individual who is a U.S. citizen. Now, again, this is the federal government must afford this to citizens who've been accused of a crime or accused of treason or are counterfeiting currency or something to that effect. This doesn't necessarily apply to the states at this time. Through incorporation, through the 14th Amendment, we get a reiteration of that same language about life, liberty, and property being deprived, and a citizen having rights to due process at all levels of government throughout the United States. And of course, this was particularly aimed at newly freed slaves who were no longer slaves, but they weren't necessarily free, and or afforded the same rights, the equal protection of the laws until we get to that 14th Amendment. All right. So the Fifth Amendment also includes, again, the taking of private property. All right, we've talked about this taking clause. And again, can the government take your property? Can the government seize your house, seize your farm? And the answer to that is yes, they can, but you must be justly compensated. And again, here's a question. What is just? What is just compensation? How do we derive just compensation? If I'm going to buy a vehicle, go back to that analogy, you may want to sell it to me for $10,000 or something to that effect. I don't think that's a good price for it. I think it's worth $5,000. All right. So I don't think that your price you're asking for me to buy it for is a good price for me. I think it's too much. Flip that around. If I have a vehicle to sell and I want to sell it for $10,000, but you're telling me, no, I'm only going to pay $5,000. We don't have a deal. I don't think I'm being justly compensated. So in that situation where you have the state saying we need this property and we believe the property is worth $1,000 an acre, and you own the property and you're saying, no, this property is worth $10,000 an acre. Well, then someplace between 10,000 and 1,000, you've got to come to some conclusion, right? 10,000 may be way too out there, right? 1,000 is way too low. So what's just compensation? Again, this is a great place for the courts to come in, right? So if the state's going to take your life, liberty, or property, taking your property, it can do that. You just have to be justly compensated for that. And there's some court cases as to what proper just compensation is. But generally, rule of thumb is double the market value. If you double the market value, you're hard pressed to argue that this isn't just compensation, right? Because property is only worth what somebody else will pay for it. I mean, there may be sentimental value, There may be it's been in my family forever, or I have these great plans and I'm going to turn this raw property into something very, very, but that property as it stands always kind of has that potential. And so whatever property is selling for, that's common to that is like that property, and whatever that price is, that is the going rate. And if you double that, right, then that has to be just compensation. Okay, as far as the court is ultimately concerned. I mean, it's kind of the rule of thumb. Double the market rate, you've hit just compensation. If market rate for a building and a piece of property downtown is $500,000, and the city wants that piece of property for a park, oh man. And then saying, well, you have to pay $1 million to actually get it. Is it worth it? Again, this is where the courts ultimately come in. Some states have basically said, look, if the other kind of thing that's not written into the Constitution as interpreted is that the government has to use the property for public use, right? So that if the government's going to seize your property, it has to be taken and used for public use. And that's actually written into the Constitution. But what qualifies as public use? And we've had some local governments who've seized property, taken it, and said, okay, we're going to turn this over to a private developer, but the taxes that come from this property are then going to be used to support roads and parks and schools, which are of public use, and therefore it's okay. The U.S. Supreme Court actually came out and said that's okay. You can do that. That's up to the state. Could the federal government do that? No. But the state could, if that's what the state is choosing to do. And so we're going to leave it to the state to make that decision. So even when it comes to article or of amendment number 5 being pushed down into to the states, the truth is that not every part of the Fifth Amendment has been incorporated by the states. What does the state constitution say? And what we did in Michigan is we said, no, you can't do that. You cannot. A government entity can't take somebody's private property and then turn it over to other private entity, regardless of what the taxation is going to be. But not all states did. So now we've gathered the evidence. We're holding you accountable, right? We're taking your property. We're threatening to take your life, liberty, or property. Now we have to afford you, again, due process, which first included the warrant, right? And going through that gathering of evidence, and then the grand jury. And now we're getting to the trial. When the trial is where we get to the Sixth Amendment to the Constitution. So rights of a fair trial. In all criminal prosecution, the accused shall enjoy the right to a speedy and public trial. What's speedy? Again, it's one of those qualified questions. What is reasonable? What is probable? What is speedy? So a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. Again, this is federal, right? So at the state level, the rules may be a little bit different as to where the crime must be tried. And again, within the district that it had been committed, the district shall have been previously ascertained by law. So individuals can't be taken out of this district and then held over here before an impartial jury, right? That are not individuals who are of this district. And informed of the nature and the cause of the accusation, right? So what is it that you've broken? To be confronted with the witnesses in his against him, and to have compulsory process for attaining witnesses in their favor. So again, who is it who's making these claims that I've broken the law? Is it the police officer who got the warrant? Is it the neighbor? Who is this? Can we see who this is? And then can we question this witness, right? And so you have the right to confront your adverse witnesses at the federal level. And again, you have compulsory right. In other words, you have the right to force individuals to also come and testify on your behalf, right? If they know information that can exonerate you from a crime, you can have them brought in to testify on your behalf. Now, of course, you wouldn't want to make them too angry, but the idea is that you'll tell the truth, the whole truth, and nothing but the truth. And so you put somebody on the stand who has evidence that can exonerate you of the crime that you've supposedly committed. You should have the right to bring those individuals there. Again, in federal trials. And to have the assistance of counsel for defense, right? The assistance of counsel for defense. And we touched on this just a little bit in our last lecture when we were talking about Gideon and what we call judicial activism. The assistance of counsel for their defense. Does that imply, right? Because it doesn't enumerate it, but does it imply that if you cannot afford an attorney, you should have one afforded to you on behalf via the taxpayers? And that's not really implied by the Sixth Amendment. And even if it is applied by the Sixth Amendment, does that then get pushed down that the states also have to follow that concept as an act of government to its citizens? So the federal government may be compelled, and the federal courts may decide that the federal government may be compelled to actually afford you an attorney if you can't afford one yourself. But did the states have to do that? In most trial cases, most trial court actually happens at the state level, right? Some state crime that's actually by state police, local police officers that are actually the ones who are gathering the evidence. The local prosecutor is prosecuting the offense, right? And so, do you at the state level, is there an obligation that the state and the state taxpayers provide you an attorney? And the court came out ultimately, it took a while, but a court ultimately came out and said, yeah, you do. And that's where we get Gideon. And again, we might consider that to be judicial activism in the context that you really had judges kind of making law versus the states or the local governments or state governments making that law, which they could have easily have done. So that's the Sixth Amendment. As we begin to, or excuse me, the Sixth Amendment, and then that's the rights of a fair trial. What about in civil cases? All right, so those are criminal cases, right? In civil cases, okay, it's in suits of common law where the value of controversy shall exceed $20. The right of trial jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States that according to the rules of common law. So interesting there that here we actually have enumerated, written into the Constitution via amendment, that there's a $20 threshold, right? Well, $20 is not what $20 used to be, right? You hear this all the time. I remember when bread was a nickel. So $20 isn't what $20 used to be. So how do we apply this amendment to the Constitution? Do we apply it that the authors, right, those who authored this, what their intent was, that it was $20 and would always be $20, that they understood inflation, that they knew that things didn't, things that used to cost 6 pence don't cost 6 pence no more? Do they have that concept as they wrote this amendment, or didn't they have that concept? And should it have been inflationary? Whereas it's $20 in today's dollars, but 240 years from now, where a dollar is worth less actually in terms of its value, right? How do you compensate for that? That's a great question, right? And again, that would take ultimately the courts to decide. But if I create some federal offense and the cost of that is a civil offense, and it's over $20. If it's over $20, I have the right to a jury by trial, a trial by jury, I should say, right? So it protects the jury trial in cases over $20. The Eighth Amendment then comes to bails, fines, and punishments. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. That's again an interesting question. What is excessive? Right? What is excessive? What do you consider to be excessive? Right? The reasonable person standard. What would a reasonable person believe to be excessive? And then this idea of cruel and unusual punishment. Again, there's an and there, and we hang on these words because they're important. So why is there an and there? It's not an or, cruel or unusual. It's cruel and unusual. And that word and versus or means that they have to go together, right? So I have to believe that when you think this through, all punishment arguably is cruel. Right? All punishment is arguably is cruel. I mean, if there's not a tinge of uncomfortableness to the punishment, then there's really not a punishment there, right? Um, you break a window, your mom comes out and brings you a pot of warm cookies. You know that you eat all these cookies. That's not a punishment. You break a window and your mom says, "Hey, no dessert for a week." Okay, now it's a punishment. Now, is that cruel? I don't think that's really cruel, but at the same time, you can see that it's having a negative effect. So the idea that punishment by its very nature is always going to be, somebody's always going to argue there's a tinge of cruelty to it, or at least uncomfortableness, that we understand. The question then becomes, is this punishment cruel, which it's probably going to be, but is it unusually, not unnecessarily, but unusually cruel? What is it? What are you doing that is making this beyond the pale, that you're creating this new system of punishment that's unusual and cruel and unusual? And that, I think, is a question that the courts have struggled with, right? Because again, we think about the death penalty. I mean, the death penalty is kind of the ultimate penalty. There's no coming back from the death penalty. Is that unusual as a penalty? No, it wasn't unusual. It wasn't unusual at the time. It's not unusual today. So is that unconstitutional? And I think ultimately the question to that is it kind of depends on how you want to apply the Constitution. States like Michigan have said, we're not going to have the death penalty. We're just not going to do it. Okay. Other states like California have said, we are going to have the death penalty, or Texas or Arkansas. We are going to have the death penalty. And that's within their purview. For someone to say that that's unconstitutional, that somehow is unconstitutional because it's cruel and unusual. Well, it's cruel, yeah, but all punishment tends to be, right? Especially when you're dealing with felonies or rapes, murders, things to that degree. The question is it unusual? And the answer to that is no. So then the question is, okay, how are you administering this? And what the courts ultimately came to the conclusion is that for a time they said that the death penalty was cruel and unusual and should be unconstitutional. And then they rescinded that and came back with basically the fact that the death penalty can be the penalty, the ultimate penalty, but it has to be as humane as possible. And then in doing that and trying to make it as humane as possible, you've eliminated the unusual nature of it, I guess. All right, so that takes us through all of the Bill of Rights. Kind of the first, we're dealing with our expression. The second, dealing with our defense. The third, dealing with our private property or home being our home. The fourth being how we secure that, and whether or not the state can go through that, seize that. The answer to that is yes, but there's a process to that. Then what happens if they find something that they're going to hold us accountable for? What are our rights? That's the Fifth Amendment, the rights of due process, life, liberty, and property without due process. And then once they've said, okay, we've gone through these due process rights, now what? Now it's the trial. What are your rights afforded as a trial? Do you have the attorney? The answer is that. Do you have a jury trial, impartial jury? Where is it being held and carried out? What about if it's a civil infraction versus a criminal infraction? Well, that's where we get the Seventh Amendment. Anything over $20 allows you to have a jury by trial. Does that still exist today? And then the Eighth Amendment, you've been found guilty of breaking the law. The Eighth Amendment then is what is the punishment, right? What is the bail? What is the fine? What is the ultimate punishment? And those things, again, are all tempered. And everything is tempered and controlled to give you, the individual, the citizen, right, the fair shake, the fair shot, and put the onus upon the state to go through each of the steps, to protect those steps, to afford you each of those steps, and to ultimately prove its case against you before you're held accountable or somehow harmed by your state, by the government. And then, of course, we talked about the 9th and 10th, which cap the Bill of Rights as really contractual language that address those issues that Madison had brought forward. All right, you guys, that's kind of it. That takes us through the whole of the Bill of Rights. Next week is Thanksgiving week, and I'm probably not. I'm not going to get on. There's no reason to get on. Just make sure you're reading your the Bill of Rights, getting studying. We have that test coming up the week after. So no test next week. Test 3, which is over the Bill of Rights, the week after that. Okay. If you have any questions, don't hesitate to email me, williamsj@kellogg.edu, and I'll have a good Thanksgiving. I'll see you guys in a little more than a week. All right.